Hello, I'm Debojit Das, and this is LiveLaw Daily. Today, August 14th, is Partition Horrors Remembrance Day, observed in memory of those who lost their lives and homes during the partition of India in 1947. The partition displaced millions of people and left behind a legacy of loss and suffering that continues to be remembered today. And with that, let's get into the biggest stories from India's courts today. For our first story today, the Supreme Court has put the brakes on a Madras High Court ruling that had struck down Tamil Nadu's decision to offer government jobs to families who lost members in the Karur Stampede tragedy. So what is the issue here? The Tamil Nadu government had issued a government order providing compassionate appointments to eligible family members of those who died in the stampede. But on July 27th, the Madras High Court struck down that order, holding that such appointments violated Articles 14 and 16 of the Constitution. The High Court's concern was that there were already many people waiting for compassionate appointments, and making an exception for the Karur victims could open the door to similar claims following other tragedies. The state challenged that decision before the Supreme Court, and today a bench of Justice J.B. Pardiwala and Justice K. Vinod Chandran has stayed the High Court judgment and issued notice. Senior advocate Abhishek Manu Singhvi, appearing for Tamil Nadu, argued that the state could make such a policy decision under Article 162, particularly when the policy was intended to provide relief to families who had lost their sole earning member. And the bench appeared sympathetic to that argument. Justice Pardiwala asked, in substance, what was wrong with the government providing employment to the spouse, son, or daughter of someone who died in the tragedy, depending on their qualifications? The court also told a lawyer appearing for a political party, don't bring politics here. But for now, the High Court judgment remains stayed, and the Supreme Court will examine the state's challenge. For our second story today, the Calcutta High Court has questioned how the West Bengal government is deploying school teachers for census work and whether that arrangement is leaving teachers with too little time for their actual jobs. So what is the exact issue here? Government school teachers have been assigned census-related duties in some cases after their regular school hours and at locations away from their schools. Hearing petitions challenging this deployment, Justice Krishna Rao noted that if school ends at 4 p.m., teachers still have to travel home, and their weekends are already limited. The court observed that teachers could either do their regular schoolwork or census work, and suggested that the state should consider selecting only 5 or 6 teachers from each school instead of issuing a bulk order covering everyone. The idea is to ensure that census duties do not disrupt regular teaching and academic activities. The petitioners had also argued that teachers should be treated as being on duty when carrying out census work. The state's counsel, Additional Solicitor General Dheeraj Trivedi, sought time to obtain instructions. The court has now adjourned the matter to Tuesday, when the state is expected to respond to the concerns raised by the bench. For our third story today, the Supreme Court Bar Association has stepped into a dispute in Meghalaya involving the state's Advocate General, Amit Kumar. The High Court of Meghalaya Bar Association and the Shillong Bar Association had passed a joint resolution seeking action against Kumar, including his expulsion over remarks he made during court proceedings concerning the safety of women lawyers and law interns. The Supreme Court Bar Association has now urged both associations to reconsider and withdraw that resolution. The Supreme Court Bar Association said Kumar's remarks came in the context of serious allegations made by a woman law intern against a senior member of the bar. According to the Supreme Court Bar Association, the Advocate General was acknowledging the need for safe and dignified spaces for women in the legal profession, while also informing the High Court about action taken in the matter. And this is why the Supreme Court Bar Association says the resolution is unwarranted. Since the issue is already before the Meghalaya High Court, the Supreme Court Bar Association said seeking action against the Advocate General for submissions made during judicial proceedings could aggravate the dispute. Instead, it has called for an effective and confidential mechanism through which women advocates and law interns can raise grievances and seek redressal. The Supreme Court Bar Association said that the safety and dignity of every member of the legal profession must remain a collective responsibility of the bar. For our next story today, one missing legal requirement has now brought the entire criminal case against Rahul Gandhi to an end. The Supreme Court has quashed a private complaint filed against Rahul Gandhi in Uttar Pradesh over remarks he allegedly made about V.D. Savarkar. So what brought that case down? A bench of Justice Dipankar Datta and Justice Sheel Nagu found that the state had never granted the sanction required to prosecute Rahul Gandhi for the offence under Section 153A of the Indian Penal Code. Under Section 196 of the CRPC, government sanction is required before a court can take cognizance of certain offences, including Section 153A. When Justice Datta specifically asked whether such sanction had been granted, Additional Solicitor General K.M. Nataraj, appearing for Uttar Pradesh, confirmed that it had not. The response from the bench was clear. If there is no sanction, that is the end of the matter. The Supreme Court has therefore quashed the complaint as well as the magistrate's orders in the case. But how did this case begin? The complaint arose from a December 2024 press conference where Rahul Gandhi allegedly described Savarkar as a servant of the British who received a pension from them. A complaint followed and Rahul Gandhi was summoned. The Allahabad High Court refused to quash that order in April 2025, leading Rahul Gandhi to approach the Supreme Court. The case has now been brought to an end on the question of sanction. And our next story today really did change almost by the hour. So what happened at NALSAR? The Bar Council of India had initially directed all state bar councils not to enroll the university's 2026 graduating batch as advocates after reports that some students had objected to Chief Justice of India Surya being invited to their convocation over earlier remarks concerning student protests. Bar Council of India Chairman Manan Kumar Mishra called the matter serious and sought a report from NALSAR's Vice Chancellor, including details of those allegedly involved in the campaign. But the decision lasted only a few hours. The Bar Council of India later modified the order, saying that the vast majority of the NALSAR students were innocent and lifting the restriction on enrollment for the entire 2026 batch. Mishra then announced that the proceedings had been closed altogether, saying the council was satisfied that the batch had no role in any disturbance or movement. And this is where the Supreme Court comes in. While Senior Advocate K. Parmeshwar mentioned a challenge to the Bar Council of India's action, Chief Justice of India Surya strongly questioned why the Bar Council of India had intervened at all. The Chief Justice of India said that students have a right to peacefully protest, adding, even if they are wrong, assuming they have the right to protest. He also said that even if a young person makes a wrong statement, why should there be an action? The court is now set to consider the challenge, even though the Bar Council of India has withdrawn its original directions. For our next story today, the Supreme Court has brought an end to the criminal cases against comedians Samay Raina, Vipul Goyal, Balraj Ghai, Sonali Thakkar, and Nishant Tanwar over jokes concerning persons with disabilities. So what led to the FIRs being quashed? A bench of Chief Justice of India Surya, Justice Joy Malia Bagchi, and Justice V. Mohana noted that the comedians had made several efforts to make amends and promote dignity and awareness for persons with disabilities. Among those efforts was a chess tournament for persons with disabilities held in March, along with donations to organizations working with the community. The respondents also proposed 4 fundraising shows and agreed to work with Cure Foundation on programs raising awareness about spinal muscular atrophy, including programs celebrating the lives and achievements of SMA warriors. The court appreciated these efforts and quashed the FIRs. But the larger issue is not over. The court has kept the petition pending to consider guidelines to prevent the humiliation of persons with disabilities and has sought suggestions from persons with disabilities and the petitioner NGO. The court also noted that it had imposed a 3 lakh rupee cost on the comedians last month for failing to comply with earlier undertakings. So while the criminal proceedings end here, the Supreme Court will continue examining the broader question of how persons with disabilities should be protected from humiliating content. For our next story today, The Supreme Court has cleared the way for the Bar Council of Delhi election results to be declared, but there's a catch. The results will remain subject to the outcome of election disputes before the election tribunals. So, what happened to these elections? The Bar Council of Delhi elections were held in February for 23 seats, with 221 candidates contesting. During counting in April, a counting staff member, Nikhil Kumar, was allegedly caught altering voter preferences on ballot papers. An FIR followed and counting was stopped. Several candidates then sought a repoll, arguing that the tampering and other irregularities had compromised the election. The Delhi High Court rejected that demand, holding that the affected ballots had been identified and that restarting the counting from the relevant stage was sufficient. And this is the latest update. A bench of Chief Justice of India Surya Kant, Justice Joy Malia Bagchi, and Justice V. Mohana has now sent the election disputes to the election tribunals, saying there was no reason to treat the Delhi Bar Council differently from other state bar councils. The court has asked the tribunals to decide the disputes expeditiously, preferably within 3 months. Meanwhile, the Bar Council of Delhi can declare the results. The court has also directed the preservations of original election records, including ballot footage and CCTV footage, so they can be placed before the tribunals. For our next story today, the Jharkhand High Court has ruled that simply being married to a man accused under the UAPA is not enough to treat a woman's property as proceeds of terrorism. So what happened in this case? The National Investigation Agency had attached a TVS scooty belonging to Sushila Devi, whose husband Binod Kumar Ganju is accused of collecting levy for the band outfit Tritiya Prastuti Committee or TPC. A division bench of Justice Rangan Mukhopadhyay and Justice Arun Kumar Rai noted that Sushila was an employee of Central Coalfields Limited, earning around 82,000 rupees a month, and that the scooty was registered in her name. The vehicle was also purchased in December 2018, almost 2 years after a police raid in the case. The court therefore found that she had an independent source of income and the vehicle could not be presumed to have been bought from proceeds of terrorism merely because she was the accused's wife. The bench set aside the attachment of this scooty. However, the court took a different view of the two other properties, a JCB loader and a 2-storied house, finding insufficient evidence of a legitimate source of funds for those properties. And for our 9th story today, X or Twitter has gone back to the Gujarat High Court asking it to reconsider one particular direction involving the centre's Sahyog portal. So what is this about? The case concerns a public interest litigation before the Gujarat High Court over the growing circulation of deepfakes and AI-generated content on social media. In April, the court had directed social media intermediaries to onboard the centre's Sahyog portal, which is meant to facilitate coordination with law enforcement and action on unlawful online content. X or Twitter has now filed an application seeking modification of that direction, while also pointing out that similar challenges to the portal are already before the Supreme Court. Twitter's counsel told a division bench of Chief Justice Sunita Agrawal and Justice D.N. Ray that the platform's response was on its way from the United States and would be filed shortly. The court has asked X or Twitter to file its response and said it will hear the platform on its modification plea. Meta and other platforms have also been asked to respond, with the matter to come up again after their replies. That's all for today's episode of LiveLaw Daily. You can find the links to all the stories we covered in the description box below. I'm Debojit Das. Thanks for listening, and we'll be back with another update tomorrow.